Viewers, it's a stunning twist tonight on the Deepam row. In a setback for the DMK government, the Madurai bench of the Madras High Court has refused to stay contempt proceedings in the case. The matter relates to the non-compliance of orders to light the Kartige Deepam at a stone pillar atop the hillock. The division bench, however, allowed contempt proceedings before a single judge to continue, keeping the pressure on the state. Let me take you through the key observations that have been made by the court. Now, in this Deepam dispute that has escalated in the Madras High Court, what has the court observed? Firstly, that the pillar faces multiple ownership claims. There's also the observation that claims range from stone survey to the mosque property, from survey stone to mosque property. It also goes on to say that lighting elsewhere is not equal to lighting at a specific site. It has further said that proof is needed to show established custom at the location. Now, this is what has been stated by the court. Viewers, there's another twist that has come in today. The Tamil Nadu WAQF Board has now claimed that the keystone pillar central to the dispute actually belongs to a dargah under its control, adding yet another layer of complexity to the legal battle over the sacred site's ownership and tradition. The High Court is hearing arguments with the WAQF Board ready for peace talks, contrasting with petitioners as officials struggle to implement court orders amidst conflicting claims and political tensions.
They are claiming it was theirs. What were they doing about it all this while? But you've got to please understand one thing. There is no prohibition in Tamil Nadu for anybody of any faith to practice their faith, to practice the rituals and the customs of their faith. As far as Kartige Deepam is concerned, the lamp has been lit in the place it has always been lit for years and years, and it will be lit in the future as well.
It is really funny and, it's really unfortunate that this Dravid model government is taking all sorts of, confusions, all sorts of problems into this case to weaken. It weakens their stand also. So, totally unrelatedly, all these people who are against the Hindu sentiments and faith are trying to confuse people, thinking that people are fools.
இந்த கையெழுத்து போட்ட ஒரு எம்பிட்ட எதுக்குனே கையெழுத்து போட்டீங்க? விமான நிலையத்தில் எங்கிட்ட மாட்டினார், டெல்லி விமான நிலையத்தில். அவர் சொன்னாரு, பிரதர், இந்த மைனாரிட்டி ஓட்டு கொஞ்சம் விஜய் எல்லாம் வந்ததுக்கு அப்புறம் இந்த பக்கம் அந்த பக்கம் எல்லாம் போற மாதிரி இருக்கு. நாங்க இந்த மாதிரி டிராமா கீமா பண்ணி 100% எங்க பக்கம் வச்சுக்கிட்டா தான் கொஞ்சம் ஒரு ஓட்டு 2 ஓட்டுனாச்சு வர முடியும். நீ அரசியல் திட்டத்தை போட்டுக்க, நீ ரூம்குள்ள என்னவோ போட்டுக்க. இந்து தர்மத்தை, இந்து மக்களை எதற்காக உணர்வுகளை புண்படுத்துகின்றீர்கள் என்பதுதான் நம்ம கேள்வி.
You're watching the News Hour at 10, debate number 2 on Times Now, Super Prime Time.
All right, let's take this across to our guests now. Joining us, we have Kovai Satyan, who is a national spokesperson of the AIDMK. We have C. Rajshekharan, lawyer, with us. Tehseen Poonawalla continues to be with us as well. Let me come across to you first. C. Rajshekharan, with the WAQF Board also jumping in to this entire case, many would say this is exactly why we needed an amendment to the WAQF law. Because here they have come in and they've claimed all the property, saying that the site and its adjuncts. What is adjuncts is not defined. But many would say, when the dargah has at one point of time earlier in 2005 stated that they have no problem with the lamp being lit 15 meters outside of the property, why are so many others jumping in? And the court has not stopped the contempt proceedings for that matter.
Madhav, there is an interesting twist in the whole case of this contempt petition which you are now bringing in this debate. There is an impeachment motion moved against the judge in conversation, and the same judge is being allowed to proceed with the suo motu contempt, which he has taken against the Chief Secretary and the ADGP, Law and Order, and others. So we have to wait and watch before jumping into conclusion. Secondly, whatever the facts before the government, the HRNC, the WAQF Board, and the temple administration has to be brought to the division bench knowledge and on record. So that is what all these representatives, the respondents are trying to do in this case. So when a single judge has passed an order and the government, the HRNC, has gone on appeal before the division bench, they have to submit the facts. They have to argue
But
the case
Mr.
on merit.
Rajshekharan, you're a lawyer. Why is the court order not being complied with repeatedly? You've not got relief from the High Court. You've not got relief from the division bench. You've not got relief from Supreme Court. Go ahead and comply with the order. Otherwise, there will have to be contempt proceedings.
No, there is a due process being followed. A single judge order has been appealed to the division bench, and meanwhile, simultaneously, there is an impeachment motion against the single judge.
Sir, is the
So
impeachment motion a
the
legal
judge-
process
No, no,
or is that a
please,
parliamentary
wait.
process? I am saying
See,
that in
I'll
this
tell you,
particular
the same-
case,
same
if you do
process,
not have
due process
relief,
will be followed in the court
if you do
proceedings
not have
also.
relief order, let me
Sorry.
bring Koe Satyan. Koe Satyan, I'm not
I'll tell
understanding
you.
this argument because here, of course, everyone has a right to appeal in this country. Everybody has a constitutional right to go to a higher court and appellate court. But in this particular case, what is quite intriguing is why there is a stubborn refusal to in any way accede to what is being stated by the bench in this case, whether it is a single judge or the division bench.
Madhav, shifting of goalpost has not come now. It is there in the gene of DMK. But as far as this case is concerned, it's yet another classic example of the incompetence of DMK government. But to the surprise, let me tell your viewers, I'm breaking this here in Times Now. Even initially, I thought it is going against the majorities in the DNA of DMK, and that's why they are taking up and breaking up this Tiruppuram Kundram issue on religious lines because elections are around the corner. Now today, the property being claimed by the Dargah under the WAQF Act clearly indicates that the political fortunes of the Prince Udaynidhi is dependent on this case, and that's how it has been tailor-made. Chepauk constituency, where Udaynidhi is the present MLA, where he is going to contest again in the same place, has got about 20% of minorities, particularly from the Muslim community. And going forward, looking at his political fortunes not in his favor, this is a tool. Tiruppuram Kundram is a tool for appeasing minorities, as well as it is directly linked to the political fortunes of Mr. Udaynidhi Stalin.
Tehseen,
That's why today WAQF has come into the picture.
Yeah, Tehseen, respond to that. It's linked to the political fortunes of Udaynidhi. WAQF is coming into the picture. It's very clear sign of nothing but appeasement happening on part of the DMK. Please respond to ADMK.
As Mr. Chidambaram rightly said, the member of parliament from Tamil Nadu, that the lamp was lit, like every year it is lit. Now, what the order has been given by the single bench, as the lawyer on your panel said, has been appealed to a higher bench. And what the answer of the higher bench will be, that will be taken place. But today here on this show, the AIDMK spokesperson suddenly remembers that DMK is wrong. I'm not a supporter of DMK. But his own organizational secretary, Jaya Kumar, is saying that BJP is doing politics in the state. Jaya Kumar, your own organizational secretary. Now, sir, are you correct or your organizational secretary is correct? The fact of the matter is, anywhere that the BJP thinks it can grow, and this is a pattern, and bear with me for 30 seconds, look at the states where the BJP thinks it can grow, or it has grown. The only narrative is the state government there is anti-Hindu. Be it Tamil Nadu right now, be it Kerala, be it West Bengal, be it Assam, anywhere that the BJP sees itself to grow or it wants to get governance, or in 2014 in India, it will say, oh, the government is anti-Hindu. Does the BJP have anything to talk about how it can beat Tamil Nadu?
I'm going to allow Sanju Verma to come in on that because I have an additional to that question. It's happening for political reasons, says Tehseen Poonawalla, and that's quite obvious what the DMK would also be stating. But I want to ask you, because the HR&CE department has stated in the court that the temple historically belonged to the Jain tradition. How then are you going to argue that this was very much a Hindu tradition? What is the evidence of the same? Because even the court is asking that question now. Sanju Verma.
Madhav, very quickly, let me just say this, that the Pandya kings, way back in the 6th century, built the Subramaniam Swami temple. And this Dargah that we are talking about, it came into existence in the latter half of the 17th century. And the Tiruppuram Kundaram hill, the entire premises, they have 3 religious, sites. One is the Dargah, one is the Subramaniam Swami temple, and one is the Vishwanath temple. So the first point I want to make, you look at the civil courts judgments dating back to 1920, 1923, 1937, 1941, pre-British era, and later on as well, British era and later on as well. The first thing that I want to make very clear is that the entire hillock belongs to the Subramaniam Swami temple authorities. It is their generosity that they allowed the dargah to come up in the same premises. That's my point number one. Point number two, which I want to state, is that there are two very important judgments, one dating 1996 and the other 2017. The 1996 judgment clearly said that the devotees have the right to lit the Deepam anywhere at a traditional place on the premises of the temple, but what is a traditional place was not specified. But the 2017 judgment clearly said one very important thing, the most historic judgment on this Deepam controversy. It said that as per the HRCE Act of 1959 and the revised HRCE Act of 1986, it is the locus standi of the temple administration to determine what constitutes a traditional place. The state government has no business to interfere. And if the temple management decides that the Deepam has to be lit on the Deepathun, so be it. So my rebuttal to Mr. Rajasekharan is, when the 2017 judgment has not been breached, how can the DMK and Priyanka Vadra and the likes of Supriya Sule even bring in an impeachment motion which basically
respond to that? All right, C. Rajasekharan, respond. C. Rajasekharan.
Say, Tamil Nadu is totally a different state compared to the North Indian states. Here, Hindus, Muslims, Christians all live together as brothers and sisters. There is no issue till BJP wanted to do some politicking. Fact of the matter is, let me make things very clear. It has nothing to do with Hinduism or Hindus in Tamil Nadu. It is the Hindutva forces which is trying to divide in the name of religion and milk the issue out of proportion for their political gains, which is not going to work in Tamil Nadu. That is the reason I didn't want to go into the political angle, but I am forced to do it because you are giving a different twist. See, there is an order. Yes, I agree. 2017, there is a judgment. That according to the judgment, Madam Jayalalitha's government, then and later on subsequently Edappadi Palanichami continued the same government, the mandate Madam Jayalalitha got.
Okay, last question. Very quick response, Sanju Verma. Why didn't you go for this earlier? You're trying to alter the status quo is what Karchi Chidambaram and the Congress party is saying. Quick response, please. Almost out of time.
My quick response is this, that you can bring in an impeachment motion against a judge only if he or she is trying to change the core religious practice. In 2018, when CJI Deepak Mishra gave the famous Sabrimala judgment, he actually said whether you're menstruating or non-menstruating, any woman can enter the Sabrimala, whether you're 5 years, 10 years, 25 years, 35 years, 65 years, does not matter. But that time, despite
well, what is the misconduct on part of the judge? There are certain specified conditions, and whether there is misconduct or not, well, perhaps Parliament will decide on that. I'm completely out of time. I'm sorry I have to interrupt you over there. Sanju Verma, Kowai Satyan, C. Rajasekharan, and Tehseen Poonawalla, I'd like to thank all of you for joining us. I also spoke to the WAQF Council in this particular case. Mr. Abdul, listen into this interaction. Joining us now is the WAQF Council, Mr. Abdul Mubin, who actually argued this case. Mr. Mubin, let me begin by asking you that as far as today's proceedings that took place, as far as the Madras High Court is concerned, the argument that has been put forth is that the land in which that Deepathun or the pillar is, where the dargah is situated and areas adjunct to it, is actually land that belongs to the WAQF. Is the entire issue now about the lighting of the lamp or about the ownership of the land?
Sir, I would give a clear picture on this. The findings of the learned sub-judge in OS number 4 of 1920, where the judgment was delivered as early as in the year 1923, makes it very clear that the mosque or the dargah, whatever we call, and this is the word which has been coined, as early as in the year 1920, and its adjuncts. We all know, as far as the word adjunct is concerned, that which is added along with the premises which is already in existence. And more so ever, what I would again elicit before you on this channel is the WAQF is a notified, surveyed and notified WAQF. Having surveyed and notified by the advent of the WAQF Act as early as in the year 1954, it is very clear. It is only the mosque premises or the dargah premises or the WAQF premises. What are all the things that are attached along with the premises also comes within the ambit and scope of the word called adjunct, which has been used by the learned judge in this before this.
But then, you know, what will be the limit? Because that adjunct also has to have certain limits, and what does that contain becomes important, because the other side is exactly argued the opposite. They are quoting the 1920 judgment. Permit me to just quote what they have said. They have claimed that the 1920 judgment permits the devotees to light the lamp at a distance of 15 meters away from the dargah. And in fact, in that sense, they say that the Dargah committee should agree to this arrangement and allow the practice, especially when there is a judicial order. And they are quoting the 1996 order saying that the lamp can be lit at a location 15 meters away and that this order has not been challenged.
1920 judgment does not speak about lighting the lamp at all.
1996. 1996, I'm saying.
1996, yes. Yes, the single judge of this honorable court, as it then was, His Lordship Justice J. Kanakaraj, as he then was, had passed a judgment. But that order, I would say that it is not a positive declaration, and it also does, it cannot be read into in such a way where you read. I would say that the order passed in the year 1996 more clearly says that it is not about the lighting of the lamp at the Deepam. It is about the lighting of the lamp at the top of the hill. The word Deepam has been coined for the first time in 2025 in this writ petition.
Okay, so you're saying that the lighting of the lamp is not a customary practice. Now, what exactly happens if the devotees go ahead and light the lamp?
Yes, I'm happy that you have asked me this question. There was an attempt to light the lamp as early as in the year 1862 and also in the year 1912 on the top of the hill. The then collector did not permit them to light the lamp on the top of the hill. The reason was there was no such custom. That is also the finding which is found in 1920 judgment. The finding of the judgment is very clear. It says it was neither a custom nor probably it could hurt the sentiments of the other religious people. This is what has been stated. Therefore, we could safely conclude on this aspect that it was not a custom even in the year 1862. Can it be said that when it was from time immemorial, if it is said that it is from time immemorial, should it not be explained? Should not there be any one iota of evidence to prove or to prima facie establish that there was a custom of lighting the lamp at the Deepam, so-called Deepam, according to them?
I may refer to a resolution that was passed in the Peace Committee meeting held on 1/12/2005 in the office of the RDO. The Dargah management had signed the minutes expressing their no objection for lighting the lamp at the Deepam. They made it clear that the lamp can be lit at any place beyond 15 meters from the Dargah. Now, this is very clearly stated. If the Dargah committee does not have a problem, then why should anybody else have a problem?
It may be said that it is a resolution that was passed in the Peace Committee meeting.
Correct.
May I take you to the very same judgment, which also says that it is not enforceable. Please read the next line. They made it clear, I'm reading the judgment, paragraph 40. They made it clear that the lamp can be lit at any place beyond 15 meters from the Dargah, though this is not an enforceable resolution. The learned judge gives a finding saying that this is not an enforceable resolution.
No, but the question still remains. If the Dargah committee does not have a problem, then why should anybody else?
No, Dargah committee says, even according to this resolution, the Dargah committee says 15 meters away from the Dargah. But if it is 15 meters away from the Dargah, it only says 15 meters away from the Dargah, and why it says is based on 1996 judgment. Please refer to 1996 judgment. 1996 judgment does not come from Dargah.
Isn't this location where the Deepatun is being sought to be lit, isn't it more than 15 meters? If I'm not mistaken, it's 50 meters away.
That is why today I have taken up a stand, very clear stand before the Honorable High Court, the Honorable Division Bench of the High Court, saying that the area, the demarcated portion with regard to the mosque waqf or the dargah waqf is very clear, wherein the mosque and its adjuncts, within the periphery of the adjuncts, this Deepatun lies. This Deepatun, which has been coined for the first time, I would say it's an ancient stone pillar. When I say
that is your claim. That is your claim, sir. But many will argue also that this is exactly why we needed a law to amend the existing Waqf Act, because you have a situation where in your own state of Tamil Nadu, there have been bizarre situations where Waqf has claimed temples, several other properties. There are even claims that have been made to Parliament, so on and so forth, which is exactly the need to amend the Waqf law is once again highlighted in this case, where again Waqf Board is coming forward to claim what is clearly the subject of some kind of a controversy or dispute.
With great respect to you, I would say, yes, the amendments to the Waqf Act bring some relief to certain issues, and again, it acts as a weapon to other issues. I do not want to go into those aspects, but as far as the Waqf Act is concerned, the matter is sub judice. I will not comment on that.
All right. Mr. Abdul Mubin, thank you for joining us and sharing with us your perspective.
Great. Thank you so much. Thank you so much.